We're going to resume our discussion on the Constitution right here. We're going to kind of zoom through this pretty fast when we talk about the preamble. We've already kind of broken it down in class and talked about what each of the phrases mean, but we're going to kind of review that right here. So the preamble serves as the introduction to the Constitution, and it provides a way for the framers to state the aims and the goals that they want to meet in this document, just like any introduction to a paper does. So these aims include forming a more perfect union, establishing justice, providing for a common defense, promoting the general welfare, as well as other goals and aims. So the framers want to make it clear where the government's power comes from. And the words "we the people" label the American people as the source of authority over the government and its leaders. And the writers of this document were very, very clear when they wrote that the source of the authority is coming from the people, which makes sense when you look at it in the context of when it was written. Right after the American Revolution, we got rid of a king, and we want to give the people the authority, not a central government. So an excerpt from the preamble, or the preamble itself: "We the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America." And we've talked about what each of these phrases mean and what it means in the context of our government. Let's also look at the Supremacy Clause. This establishes the Constitution as the supreme law of the land. One of the Constitution's more innovative features is known as the Supremacy Clause. So this guarantees that in cases of conflict, federal law, or the law that comes from Washington, D.C., always supersedes any state law or state statute. So anything that the states say has to be underneath what the federal law says. Some states refer to this as the linchpin clause because it joins the power of government under the Constitution. In much the way that a linchpin, shown here in the picture, that was common in many 18th century machines, would hold different parts or elements together and help it function as a unit. So this states that states maintain some sovereignty through those, what we call those reserve powers, but the Supremacy Clause guarantees that the government always supersedes the state law. And it protects against the states being able to tell the federal government what to do, which is what we saw under the Articles of Confederation, where the states had more power than the central government. And the sharing of power between the federal government and the states we also know is called federalism. Let's look at the Commerce Clause. Another fundamental clause of the U.S. Constitution deals with the regulation of commerce. Remember, commerce means business and trade. We call this the Commerce Clause because it's been used by the Supreme Court in cases to assert federalism as well as to uphold certain legislation. So the federal government has the authority to regulate interstate commerce. Remember, one of the weaknesses of the Articles of Confederation was that states got to regulate commerce within their borders, but when commerce went between states, it became a decision of who was going to get to regulate it, Maryland or Virginia, and we didn't know, so giving that power to the central government allowed us to have rules that applied to all states and not each state with different rules on commerce. So we know that the federal government now has the authority to regulate this between the states, and the federal government has the ability to regulate commerce with foreign nations, commerce with Indian tribes, and states maintain the right to regulate commerce that happens within their state, and we call that intra-state commerce. In the Supreme Court case, Gibbons versus Ogden, and we'll review this when we come to that chronologically in our discussion of history, Chief Justice John Marshall, who we saw yesterday in our video, asserted that the Commerce Clause also gave the federal government the right to regulate interstate navigation. In the case of Hart versus Atlanta Motel and U.S. Kennedy versus Katzenbach and McClung, both of those were in 1964, the Supreme Court are also going to affirm that the federal government can enforce provisions of the Civil Rights Act of 1964. And the Civil Rights Act of 1964 makes racial discrimination illegal via the Commerce Clause. So this Commerce Clause deals not only with commerce and trade, also getting into some civil rights law. Let's look at the Electoral College. We heard a lot about this in recent months due to the presidential election. Um, so we know that we use the Electoral College for presidential elections. The creation of a very powerful executive branch in Article 2 of the Constitution concerned many of the framers, and they believed that the average voter might not be informed enough to make a legitimate decision about who should be president. And no one questions George Washington's ability or character at the time, but there was no guarantee that men of lesser ability or character might be elected in later years. So, in order to protect this office from the general population, the people, they're going to put this protection in there. So, the framers answered with this electoral college. The state has a slate of electors equal in number to its congressional representation. So if we have 32 members in the House from Texas and 2 senators, that means we get 34 electoral votes for the state of Texas. And after the popular vote for president, these electors would then travel to their respective state capitals and cast votes for 2 different candidates. The total electoral vote would be counted and announced in a joint session of Congress, and originally the candidate receiving a majority of electoral votes would win the presidency, and the runner-up would be elected vice president. But this becomes problematic when the one with the most votes is from one political party, and then his runner-up, his vice president, happens to be from a different political party. They don't get along. The system did and does have drawbacks. In 1800 and 1824, no candidate is going to receive a majority of electoral votes, and so the vote comes to a tie. The House of Representatives then has to decide the election. In other instances, most recently in 2000, which most of you probably weren't born then, but I remember, the presidential election was contested. The candidate who received majority of votes in the popular vote lost the electoral vote. So political parties that happen soon after Washington's election are going to relegate the Electoral College to a rubber stamp system. And this means that the electors who technically can vote for anybody are going to pledge loyalty to the candidate of their political party. And any dramatic changes in the Electoral College system as the way it is now seems pretty unlikely. Even the smallest state has 3 electoral votes, which we know is Rhode Island, and which gives small states more leverage than they might otherwise have in an election process. And in addition, election law makes it difficult for third parties to win electoral votes, since they usually don't get enough of the popular vote to win an entire state's electors. So it really does give us this 2-party system that we have, and until we get rid of the Electoral College, it's unlikely that anybody from another political party would be elected to the presidency. The Constitution is going to solve a lot of problems that we had under Britain, also under the Articles of Confederation. So this system of checks and balances is going to curb the excessive power by one single branch. And we spent some time talking about this in class, this system of checks and balances, and we usually draw it as a triangle, and that each of the vertices of the triangle is one of the branches of government, and that ideally that travels in kind of a circle, and that no one branch is more powerful than the other branch. And while the Constitution allows for a very strong central government, a system of separation of powers and checks and balances ensures that no one branch becomes overly powerful. The Articles didn't provide for an executive branch. However, the Constitution creates a powerful executive branch with the ability to propose legislation as well as veto bills passed by the legislative branch. So they have a check on their power. And though Congress can, by 2/3 vote, override a presidential veto, and we know that that's one of the protections from that executive branch becoming too powerful, is by giving Congress the ability to override that veto, we still like that executive has a lot of power. Another glaring weakness of the Articles was it was eliminated by the creation of this national judiciary. It includes a Supreme Court and a hierarchy of lower regional courts that we'll talk about were created under the Judiciary Act of 1789 in Washington's administration. And to keep the various branches of government under control, the framers made each answerable to a separate constituency. A constituency is the people that vote for you. And since all bills to raise revenue have to originate in the House of Representatives, which is that lower branch of the legislative branch of government, the lower house, excuse me, of the legislative branch of government, the people would vote for their representatives directly. State legislatures initially would elect members of the Senate, and this function, the framers are going to see as very similar to what Britain had in their upper house, so the House of Lords. We call it the Senate. And the Electoral College would elect the president. So the people were initially only really electing that lower branch of the House. And lastly, in an effort to keep the government vital enough to face new challenges, the framers are going to add this necessary and proper clause, also called the elastic clause. And we talked about that in our discussion yesterday about how the legislative branch, at times in history, have taken liberties with that power and used it to greatly extend the power of the legislative branch. All right, let's look at some discussion questions over the previous things that we've just talked about. Number 1, what purpose does the preamble serve relative to the entire Constitution? Number 2, what does the Supremacy Clause provide for, and how does it do this? Number 3, what does the Commerce Clause allow the federal government to do, and how was this an improvement over the Articles of Confederation? Number 4, why did the framers include the Electoral College in the Constitution, and how did this system originally work? Number 5, what were some problems of governance under the Articles of Confederation that the Constitution solved? You'll answer those, bring those with you to class tomorrow. We'll discuss those questions and move on. Have a great evening.